morning, Ellen and Howie here with another informative video that we hope will help you decipher some of the myths and falsehoods and truths surrounding guardianship here in Florida. So there was a recent media event which highlighted guardianship in a very negative manner, and we want to speak to just the generalities, the benefits, and the concerns of our guardianship system.
Right, so I think it's really important to remember when we're talking about guardianship that it is a legal system that is designed to allow others to manage the assets and make medical decisions for people who are incapacitated and can't do those things for themselves. And while it's not a perfect system, it is a very good system, but there are variances from state to state, and Florida happens to have one of the strongest guardianship statutes in the country and serves as a model for other states. And there are built-in safeguards in the system in Florida that really do protect the vulnerable adult, the person who is in need of the appointment of a guardian. And I think it's important to remember that the cases that are in the media, those are the ones that the media are interested in reporting on. But
they're the bad apples. And one bad apple.
What gets forgotten is that the lion's share, the upwards of 90–95%, maybe more, those cases are running smoothly every day. But the one that somebody did something not in compliance with the statute, and somebody's assets were dissipated, or an improper health care decision was made without following proper protocol, those are really very rare circumstances, but they are the ones that you're reading about.
Right, and let's just talk about guardianship as a whole for a minute. So there's a family guardian or a friend guardian, and then there are professional guardians. Professional guardians have certainly been the target lately, although family and friend guardians also are targets. And what I want to make clear is guardianship is called the court of last resort. And here at Elder Law Associates, we subscribe to that theory, which is why you may have seen a video that we've put out on advance directives. I mean, if you execute your advance directives, your durable power of attorney, your designation of healthcare surrogate, even a revocable trust, those documents will likely avoid the necessity of any guardianship because you've named somebody to make decisions for you, both financially and personally and healthcare wise, in your place should you become incapacitated. It's when you don't have those documents, or in a professional guardian situation, when there are no family and friends available to step in, that thank goodness we do have professionals who are able to do this for people who would otherwise have no one else.
And let's remember that if you don't want a stranger who is also a licensed professional handling your affairs, that is what the advance directives allow you to do. And oftentimes in a situation where somebody doesn't have anybody, that's a circumstance where a professional can be appointed. But another circumstance where the judges will appoint a professional is when the family doesn't get along. And if people are vying for being appointed the guardian and there's a conflict, the judge looks at that situation and says, you know what, I'm not going to appoint either one of you, son or daughter. I'm going to appoint an independent third-party professional. But had the individual taken the time to plan and sign their advance directives, they could have stated in a pre-need guardian document, which we have here in Florida, their own preference for who should be the first appointee of guardianship, and if that person cannot serve, then who can be the alternate appointee.
And that pre-need guardian document is binding on the court. And let's not forget, again, that there are professional guardians who, but for their services, the individual or the ward would have nobody to make that decision for them, or would be stuck with warring factions of either sides of the family, incurring huge amounts of lawyers and litigation fees. Now, our professional guardians that we represent, they are bonded by the court, or everything that the ward owns is put in a restricted account, and everything they do is done via court order. in our office, we've never had an issue with a professional guardian doing anything that was illegal or improper or abusing the ward's funds. And we would never, because we oversee our guardians and our family guardians.
Right, so we try to do our part as elder law attorneys to contribute to the overall success of the guardianship program. Certainly our colleagues in the elder law bar do the same. It's also important to remember that the professional guardian, or anybody who's serving as a guardian for that matter, because they are handling the assets and making medical decisions for another, as part of its oversight authority, the court has an individual who reviews the transactions that have occurred, and you are accountable to the court for what you've done with this individual's money. So that's just another safeguard that's in place.
And it's pretty hard to act in a tunnel, isn't it? I mean, these media cases, there had to have been some collusion with others in order to achieve the theft and the fraud to the level that some of the media cases have outlined.
I agree. So it's not always the case that it's just one bad actor. Oftentimes you have to come up with a whole plan that involves multiple parties in order to effectuate that kind of deeply rooted fraud and misappropriation of assets.
Right. So, the elder law section of the Florida Bar, the Academy of Florida Elder Law Attorneys across the state of Florida, the task force of the Florida Bar members, we're focused on this issue. We are doing everything we can to ensure that Florida continues, because we do already have the strongest and most protective laws for wards and vulnerable adults and children alike out there, and we will continue to do so.
Yeah, so I think in conclusion, our message today is, while there are some isolated cases where the system doesn't work the way it was intended to work, on the whole, the guardianship system accomplishes some very important and integral objectives that are helpful to the citizens of the state of Florida.
And on the whole, professional guardians are not making a lot of money doing this job. They're really more like social workers, and they're doing jobs of love. And without them, the vulnerable would be in serious trouble.
So thanks for joining us today, and we hope you have a great day.